So I think this is an important point. So what you're telling me is your view or understanding of the law is that the law can in fact compel people of religious faith to speak against their own faith and their own viewpoint. The law can do that. And if it's labeled as neutral, but it just so happens that it compels religious believers to violate their sincerely held religious beliefs, that's okay under the First Amendment. Is that correct? Is your understanding of the law as it currently exists?
No, Senator Hawley, I'm not aware that the U.S. Supreme Court has addressed the nuance of a free exercise claim coupled with a free speech claim, which is what you just described. What I referenced earlier was a straight-up free exercise claim, and I think that the U.S. Supreme Court hasn't backed away from Justice Scalia's decision in the Smith case in terms of the applicable law.
So you stand by your representation of this client and all of the arguments that you made, including calling the position of these two Catholics, Malcolm and Susan Baker, invidious, pernicious, and akin to racial discrimination? Do you regret any of that rhetoric?
Senator, I don't remember the context. I haven't looked at that brief in 30 years.
Listen. There are moments in Washington where everything suddenly feels different, where it stops being routine politics and turns into something much bigger. A real test of what this country actually stands for. What you are about to see is one of those moments a United States senator asks a question that cuts straight to the core. Can the government force people of faith to speak against what they believe? The answer that follows sounds careful, sounds polished, but never truly confronts the reality of that question. And that is exactly why this exchange hits so hard. Before we break it down, hit like, subscribe, and share, because your voice carries more weight than you think. People in Washington are listening, and we are going straight into what just happened.
Linda Paquette in 1994, who demanded that two devout Catholics print custom membership cards for an organization that advocated in favor of abortions. When they declined to do so, citing the teachings of their church, you and your client filed a complaint with the Vermont Human Rights Commission and then a lawsuit. And in your briefs, you argued that their decision not to print those materials was invidious, it was pernicious, and it was akin to racial discrimination, which is quite a claim. I mean, it's really quite a claim. And I have to ask you, why did you feel it was important to leverage the machinery of government? This is a private business. These are two private individuals. Why did you feel it was important to leverage the machinery of government to force these two Catholic business owners to violate their sincerely held religious convictions? Help me understand this.
Thank you, Senator Hawley. As I indicated with Senator Cruz, that case was 30 years ago, so I apologize if I'm not as precise about all the details, but I can tell you, generally speaking, that we conceded that if the printers had declined to print the materials on account of their opposition to abortion, that there was no basis in law to pursue our claim. The threshold issue in the case is whether that in fact was the facts. My client was a Catholic. She was there to get flyers for Vermont Catholics for Choice printed. She was deeply offended by the suggestion that she wasn't a true Catholic, and that was the reason why the printer wouldn't print the materials. The case never proceeded beyond that stage. We went up to the Supreme Court on what I would call a procedural issue. We went back down and the case settled, and that was the end of it.
Well, I can understand the issue if the government had told your client that she wasn't a true Catholic or a true Hindu or true whatever, given our First Amendment. But we're talking here about a suit against two private individuals, husband and wife, I believe, Malcolm and Susan Baker, who on the basis of their religious viewpoints said that they couldn't print these cards. And you and your client attempted to leverage the machinery of the state. In fact, you were the ones trying to use the machinery of the state to compel these two private individuals to speak. And of course, the Supreme Court has addressed this fact pattern in the Masterpiece Cake Shop case since that time, which concerned compelled speech. In light of Masterpiece Cake Shop, do you acknowledge today that your client would not have the right to compel other individuals to speak in a way that she favors?
Senator Hawley, I don't read the Masterpiece Cake decision as altering the Smith holding that neutral laws of general applicability apply without regard to a free exercise defense, nor do I understand the court to have resolved the speech claim. As I read the Masterpiece Cake decision, it turned on the fact that the court concluded that the process in the Colorado Civil Rights Commission evinced hostility toward religion, And it wasn't, in fact, a neutral law of general applicability in that respect.
So I think this is an important point. So what you're telling me is your view or understanding of the law is that the law can, in fact, compel people of religious faith to speak against their own faith and their own viewpoint. The law can do that. And if it's labeled as neutral, but it just so happens that it compels religious believers to violate their sincerely held religious beliefs, that's okay under the First Amendment. Is that correct? Is your understanding of the laws that currently exist?
No, Senator Hawley, I'm not aware that the U.S. Supreme Court has addressed the nuance of a free exercise claim coupled with a free speech claim, which is what you just described. What I referenced earlier was a straight-up free exercise claim, and I think that the U.S. Supreme Court hasn't backed away from Justice Scalia's decision in the Smith case in terms of the applicable law.
So you stand by your representation of this client and all of the arguments that you made, including calling the position of these two Catholics, Malcolm and Susan Baker, invidious, pernicious, and akin to racial discrimination. Do you regret any of that rhetoric?
Senator, I don't remember the context. I haven't looked at that brief in 30 years.
So does the passage of time make it any different? I'll give this to you for the record, and that'll allow you to refresh your memory, but I'm quoting you, invidious, pernicious, akin to racial discrimination. As you sit here, does that not trouble you? You're describing the religious beliefs of practicing Catholics who are citing the teachings of their church. You think that's akin to the Ku Klux Klan?
Senator, the threshold question in the case, which I suspect I will find is what we were addressing in that passage, was whether or not this was discrimination against my client on the basis of her religion.
And you were saying that these two Catholics who did not want to provide the speech, you engage in the speech your client wanted them to on the basis of their faith, doing so was akin to religious discrimination. Listen, I have to tell you, the last president sent somebody up here to this committee who made that exact argument. It's a Republican who made that exact argument. I voted no. That person didn't get confirmed. I've got profound concerns, Justice Robinson, about your position here, and I have to tell you the passage of time doesn't do anything to alleviate my concern.
There is a reason legal arguments sometimes sound simple. It is usually because the hardest truth is being avoided, and that is exactly what Senator Hawley pushed into the spotlight. A real case, real people, two Catholic business owners who refused to create something that directly conflicted with their beliefs, not out of hate, not to deny anyone service, but because they believed it crossed a line they could not ignore. And if you have ever faced a moment where your job asked you to go against your conscience, then you already understand how real that pressure is. Senator Hawley takes that tension and forces it into the open, asking if a law is called neutral but still pushes people to act against their faith. Is that really freedom? Judge Robinson responds the way courts often do, leaning on precedent, explaining that neutral laws can still stand even when they impact religion. And legally that framework exists, but this is where the conversation shifts because Senator Hawley refuses to keep it abstract. He brings it back to reality, pointing out that those same believers were described with words like invidious and pernicious, language usually reserved for serious wrongdoing. And suddenly, this is not just about legal theory, it is about whether faith is respected or quietly treated as a problem. And that difference matters because the moment belief is only protected when it aligns with the system, it stops being true freedom. It becomes conditional. History shows that line does not stay still. It moves, and it keeps moving. The law has to balance rights, that is true, but Senator Hawley makes it clear the line is crossed when the government compels speech, because forcing words is not just regulation, it is control over conscience. And that is where the First Amendment was meant to draw a hard line. This is bigger than one case. This is about the direction everything is heading right now. If this made you think, speak up, like, subscribe, share, and drop your thoughts, because these conversations matter more than most people realize. And yes, Washington is paying attention.